Hey, good afternoon, everyone. My name's Ted Steinkamp. I'm with Advanta IRA, and we're going to be doing today's webinar on exploring alternatives to the Stretch IRA in the Post-Secure Act era. As I mentioned, I'm with Advanta, and there we go. And I've been in the financial services industry for 35 years. Today, I'm over here at Advanta. And I will have to say it's very refreshing change because once I thought I knew everything about this business, things changed dramatically when I came over here. But if you notice down at the bottom is the contact information. If you have any questions regarding today's webinar, you want to reach out to me via phone, email, feel free to reach out and contact me. But I just want to go through a couple of slides here before I bring on the guest speakers, just cover a little bit of territory that may be somewhat familiar to a lot of you. And if it's not, it'll be something new. We can certainly have a conversation later if you wish. But just a little quick background about Advanta IRA. We've been around over 20 years. As far as our colleagues or my colleagues here at the company, number of us have legal backgrounds and professional industry designations. So we are very experienced and we are subject matter experts in these areas. We custody self-directed IRAs for over 13,000 clients, and that equates to a little bit over $3 billion in assets. Also, too, we are very solid and secure, even though you do have investments in self-directed IRAs. Any cash balances, we maintain those on behalf of clients in FDIC insured institutions. And of course, we're all about people, whether you're our client or whether you work here at Advanta. We want people interacting with each other because that's where we both really shine. So every Advanta IRA client does have a dedicated account manager, and we are very much into personal service and ease of doing business. We also work with an awful lot of different asset classes within the self-directed IRA space. So feel free to ask your account manager about any questions about any future investments you may be making. Just a quick question we're always approached about is, what is a self-directed IRA? I haven't heard of this before. Where does it kind of fit in? But self-directed IRAs really allow you to invest in non-traditional investment assets. Gives you complete control, gives you a better degree of control in some aspects because it does allow you to invest in things that you may know better other than just your traditional stocks, bonds, ETFs, mutual funds, etc. And these are typically investments that you're going to hold that are going to be outside of the stock market. So if you don't happen to like the ups and downs that financial markets provide, perhaps self-directed investing is something that's going to be for you. Now, why would someone really want to pursue self-directing? Well, for a couple of reasons. First of all, there's a financial reason. Many of us, when we invest, we have two options. We either use cash out of our bank accounts, or we're going to use the monies that we have saved through a 401k plan or perhaps an IRA of some kind. Sometimes using your own personal cash in the bank accounts is not necessarily an option that you want to pursue. Perhaps it's your emergency fund money. Maybe it's tuition money for your children. You don't want to upset that. So that would make the IRA investing something that's potentially very attractive to you. Also, too, on the self-direction, as I mentioned, stock market fatigue. If you're just tired of the stock market and you want to try something different, perhaps for improved returns as well, self-directed is a great way of doing it. And then, of course, taxes. If you're like me, you hate paying them, but you have to. It's imposed. But keep in mind the old adage, it's not what you make, it's what you keep. And this is where self-directed IRAs can really shine. All the profits, the dividends, any sort of income payment that gets paid goes right back into your self-directed IRA accounts. You don't have to pay taxes on it. So it's either tax deferred, or in the event it's a Roth IRA, it's tax free. Now, why is this not as well known? Well, quite honestly, this has been around since 1974, the same as IRAs. but it's just not the dominant business model. Most IRAs are going to be held at brokerage firms and banks, and to some extent insurance companies, but it's just not their business model. They don't custody these types of assets, and they're more focused on the assets that they can sell because, quite honestly, that's where they make their money. And the IRS does not put any sort of stipulations on the IRA investments other than they cannot be life insurance contracts or collectibles. But however, custodians are not required to hold all types of assets for IRAs. We like to equate this a lot to, say, going to McDonald's. All of us know this pretty well. We know what their products are. But if you were to go to McDonald's and ask them where's the local pizza place, they're not going to tell you. They're not in the business of selling pizza. They're in the business of selling burgers. Not much different with financial service providers. A couple of things I want to focus on here, just really why are retirement funds really a very good capital source for investing? Well, I mentioned the difference between using the money in your bank account to invest. That's a more short-term purpose. It's going to be your emergency fund, perhaps tuition dollars for your kids. But when you take a look at the focus and horizon for retirement accounts, usually we don't have problems making commitments to investments for 5 to 10 years. So this makes it very solid choice for long-term commitments to investments. Some investments take that long to come to fruition and materialize and produce the returns that you seek. A lot of investments don't really produce that much on the short term unless you're doing something like money market, and those are very small returns over time. So time in the market is more important than moving in and out of the market. If you're looking for alternatives, self-direction is a great way of doing it. You can have a lot of different options, and we can talk a little bit about that offline. But also too, when you take a look at the overall dollar amounts in retirement plans, and I'm talking the total dollar amounts between IRAs, 401ks, pensions, and annuities, it's over $37.5 trillion. Just to put that into perspective, this dollar amount is greater than the total value of the US national debt. It's larger than the gross domestic product of the United States, and it's by far exceeds the amount of dollars in the commercial banking system. This is a huge pool of funds. Now, what accounts can be self-directed? Anything with the letters IRA after it. You can also self-direct your health savings account or education savings accounts if you have those. And for those that own businesses or are self-employed, your retirement plans related to those companies can also be self-directed. Now, there's a lot of confusion out there when it comes to funding a self-directed IRA. Just want to cover just a little bit of ground here. First of all, part of the confusion, I want to direct your eyes to the bottom of the slide here. There's a lot of confusion over where does taxes and penalties apply. As long as you're doing a transfer or direct rollover from custodian to custodian or institution to institution, there's no taxes and there's no penalties involved. Transfers, you can do an unlimited number of transfers between IRAs, virtually no reporting. And when it comes to moving money out of a former employer's 401k plan to a self-directed IRA or just an IRA in general, that's a direct rollover process. Again, no taxes, no penalties involved. There's just a slightly different process of how that needs to be originated. IRAs, if you were to open up a self-directed IRA here at Advanta, you would initiate that transfer request on our end. However, if you wanted to move money from an old employer's 401k into your Advanta IRA account, that would be a direct rollover process. That would have to be initiated with the plan administrator, and we're happy to provide advice and guidance on how to execute that best. And of course, we see a lot of this over here at Advanta IRA, the different types of investors. They're always broken down into two groups: the active investors that like to roll up their sleeves, get dirty. They'll do fix and flips. They will buy rental properties, they may engage in wholesaling. They are actively engaged, hands-on people. It takes a lot of time, energy, and effort. This is very detailed oriented. And of course, we have the passive investors, which really I fall into that category. I want to outsource that stuff. I want to track the returns. I don't have a problem paying for it. So if I'm going into a private place syndication, if I want to place money with a private lender, I just want the checks to be cashed by my IRA. I don't want to get involved in it any more than that. We have both types of investors here at Advanta IRA. And the cool thing is when you're right more than you're wrong with your investments, they grow over time. And when time progresses on for all of us, we get old. Now we start looking at retirement. This is where our two guest speakers come into play. David Carter, whom is a tax attorney here in Atlanta with Carter Jeffries, and then also Kevin Meters, whom is our guest speaker from Magellan Planning Group. They're going to talk about alternatives to the stretch IRA, because when that came into place or signed into law back in 2019, as everything involved in our relationship with government, it's give or take. The Secure Act gave us a few flexibilities and some leniency as it amounts to saving for retirement, but it also took away one thing, which is the stretch IRA. So with that being said, what I'm going to do is I'm going to switch the screen over to David.
Well, good afternoon, everybody. I'm glad you all are here. We really appreciate you taking a few minutes to listen to what we have to say today. We're going to talk about stretch IRAs and some really interesting tax planning tools in just a few minutes. We're going to start by talking about family wealth preservation planning in general. I call this family wealth preservation planning rather than just asset protection planning or tax planning or estate planning, because it really is all interrelated, and you have to plan all of it at the same time, and it all has to work together. So this is for anybody who cares about their family, cares about lowering taxes, cares about protecting inheritances for the benefit of their kids, grandkids, or whomever. I always ask people when the last time was that they reviewed their existing estate plan. Most people have not taken a look at the documents they received 10 years ago in the entirety of that 10 years. They are pieces of paper that are yellowing in a desk drawer somewhere. And the importance of that is that it means that your life has changed during that period of time. And if you have not updated your estate and family wealth plan to match your life, to match your finances, then your plan is probably not going to work for you when the time comes. And of course, the question you should be asking is, when do you need your plan to work for you? The answer is some point in the future, and you don't know precisely when. So you've got to be prepared for everything, and that means keeping things up to date. If you regularly review your investments with your financial advisor, you need to regularly update your wills, your trusts, whatever your family wealth planning documents are. Family wealth planning is traditionally started with planning for death. This is a traditional will sort of scenario, and you're concerned with passing your assets down to your kids. I would tell you that there's a lot more that gets passed down to your kids, though. You probably all have friends or family members who have gone through a contentious probate process. You know, what people remember after a contentious probate process is not the things that they inherited. They remember the hassle of having to go through that process at all. The thing about probate is it's 100% avoidable, but you have to do the planning ahead of time. A will does not help you plan for life. We're all living older now, and that means we need to be concerned about healthcare powers of attorney. We need to be concerned about long-term care coverage. How are we going to pay for our extended lifetimes? If you're not talking about that with your attorney as they do your wealth planning, then you're really missing a very important aspect of your overall financial planning. If you don't have a plan at all, keep in mind that the state has a plan for you. There are statutes that say who gets what and when. The key is that a judge is going to administer that if you don't have a plan in place. That's a judge that you've never met, who has no idea who you are, who has no idea what your values are. A total stranger is going to make decisions about how your family inherits wealth from you. Probate is also public. On the screen, you can see the last will of Jackie Kennedy Onassis. This day and age, with identity theft being what it is, we all spend our entire lives keeping all of our private details private. So why at the last minute would you allow everything that you owned to be made public, along with the addresses of your beneficiaries and the executor of your estate? It makes no sense. The good news is, though, that you can avoid all of this. Another problem with receiving assets through a will and not doing proper family wealth planning is that when they inherit those assets are 100% not protected from creditors. And I should mention that creditors include spouses. So if your son inherits a large sum of money from you, or is the beneficiary of an IRA, if that money is distributed to him and his wife then divorces him, his wife will be able to claim a significant portion of that inheritance. Going back to the theme of planning for life, we all need to make sure that we have a healthcare directive that will work when you need it. If you're in the hospital and you can't speak for yourself, somebody has to be able to speak for you to give directives to the hospital and to manage your care. Have you named somebody who's going to do that? Is that person going to work with the trustee of your trust or the executor of your will? All these things need to be people working together. There are a lot of common planning techniques that simply don't work. You may have heard of people adding their kids as common tenants, joint tenancy with right of survivorship. The problem with that is that you're creating a tax burden for your kids. If they inherit your house and your house is appreciated in value, then the gain on the house is eliminated, meaning that if they sold the house on the day of your death, they would not have to pay any capital gains taxes on it. If you name them as a joint tenant, though, then there is no inheritance. They already own the house, which means whatever built-in appreciation is in the house remains their obligation whenever they transfer the house. People use beneficiary designations a lot, thinking that that also avoids probate. The truth is that it does avoid probate, but it sets up other problems. Again, if that beneficiary has creditor issues or is going through a divorce or about to go through a divorce, that gives creditors or ex-spouses or whomever the ability to reach into the inheritance and grab a share out of it. The only way to really avoid court without causing these problems is to avoid probate through a fully funded living trust. This is a revocable living trust. You maintain the control of the assets that you put into it, but it creates an envelope around your assets to allow you to transfer them to your descendants without having to go to court for permission or without having to be public. And a trust on the right way is going to provide asset protection planning. So when we talk about family wealth planning, we're talking about creating multi-generational asset protected inheritances for your kids. Everybody wants to protect their inheritance completely. Your kids do. They want to remember you for being wise. This is how you pass your wisdom down to them, is by protecting them even when you can no longer speak with them. And now the big question, what about estate taxes? Well, whatever planning you do, if you have a taxable estate, which this year is anybody with over $13.61 million to their name, and of course that is going to drop down to $7 million at the end of 2025, you have to pay estate taxes, and estate taxes take a big chunk out of the inheritance to be received by your kids. Doing your family wealth planning allows you to put in place strategies to minimize or even eliminate those estate taxes or avoid them altogether. Now I'm going to hand the microphone over to Kevin here, and he's going to talk to you about some very, very underutilized tools for passing IRAs on to your kids while while minimizing taxes and giving them as much flexibility as possible.
Thanks, Dave. Thanks, Ted. I appreciate it. Again, my name's Kevin Metters. I'm an attorney as well, focusing really on estate planning, but more into these charitable trusts. Now, Many of you maybe have heard of the charitable remainder trust, but you may not be completely clear as to what it does. It has that word charitable in there, and that scares people because they think they're giving their money away. But really, this trust is anything but charitable. It's a tax savings trust. So what we're talking about here is not giving money to charity. What we're talking about here is saving taxes, and we have different taxes that we need to watch out for. Capital gains taxes, estate taxes, gift taxes, depreciation recapture, and specifically what we're talking about today are the income taxes on IRAs and also estate taxes on IRAs. So we'll talk more about that. But let's just get the basic understanding of what a charitable remainder trust does, and generally that is used to avoid long-term capital gains taxes on assets that you're selling. So these are non-IRA type of assets that the CRT was initially designed for. So you can see that we have, long-term capital gains tax rates of about 20%. That doesn't include your state. Then also we have what we call the Medicare tax of 3.8. That's on top of that and on top of your estate. And then if you have a collectible, we've done musical instruments, we've done Stradivarius cellos, we've done stamps, we've done $120,000 bottles of wine. We had a whole case of those. So any of those things are taxed at a higher rate, which is the collectible rate of 28%. This also works for those things. The estate tax, which Dave alluded to, right now is probably okay for most people, but at the end of next year, at the end of 2020-25, we're going to go back to this 5 million number unless Congress, does something. And well, they get along so well, there's always room for that. But the basic CRT concept works like this. We have a charitable trust, and it says charitable on it because it's a remainder. Whatever the remainder is inside that trust is what charity will, or a charitable donor advised fund will get. Essentially, we have the asset, we transfer the asset into this trust, and immediately that's removed from your estate for estate tax purposes. That can be very useful. We get a tax deduction for doing it, but that's really just sort of a minor thing that I look at later as maybe a cherry on top. But the real benefit here is we're able to sell that asset inside that trust, and because the trust has its own tax ID number, it's a tax exempt trust, there are no taxes due, no federal taxes, no Medicare taxes, no Social Security taxes, and no state taxes. Next, we're able to immediately take income from that trust. So we sell the asset inside the trust, we reinvest the money inside the trust, and then the trust starts paying us income back for either our lifetime or for a period of years. It can also be for joint lives and then a period of years after that. And we'll talk more about that here in a second. Whenever all that's over, and remember, these things can run for 50 plus years. I'm running one now for 53 years. At the end of that period of time, whatever's left in there, whatever the remainder is, that's where the word comes from, whatever's left in there will go to charity or a donor advised fund, which you and your family can also control to an extent. So if you have $1 million asset and you go to sell it, and again, remember, this is not IRA, this is a non-IRA asset, so we have $900,000 in gain, then, if we're not inside the CRT, we've got to pay these taxes. We're going to lose roughly 30%, depending on your state. With a CRT, we lose no taxes. We pay nothing in taxes, so the entire $1 million remains in the CRT to be reinvested and to provide income back out to the beneficiaries. Generally, the donors, the ones that set up the trust, are generally the primary beneficiaries, but they don't have to be. They can set up their children to be the beneficiaries, or really anyone. There might be some gift tax situations that we have to look at, but it really can be anybody. Here we show that, with more capital to invest with a CRT, our income, apples to apples, instead of 61,000, we're getting 80,000 with an 8% payout rate. We've got the taxes. We still have to pay taxes on the money that's coming back out to us little by little. These are usually paid out quarterly. But you can see after the net of 26 years of lifetime income, we've got about $300,000, $345,000 more in total income, and we got a little tax deduction there. Again, I call that the cherry on top. But remember, this is for non-IRA type of stuff. So you can see we had about $400,000 in total lifetime spendable income of an increase of $300,000 or $400,000. And that's for a couple of that are both 70. And so that's just a very plain vanilla, mom and dad selling something that maybe they've had for a long time, like a farm, or maybe it was some stock. Grandpa worked for BP or something. So we can see that there's a major increase there. And that's just because we were able to save the taxes and use those taxes to reinvest and use the reinvestment to be paid out. So now let's talk about IRAs, because remember what Ted said was the Secure Act got rid of IRAs. But let's go back and talk about what IRAs are, or what qualified money is, because all of you here have an IRA, and that's why you're here, right? But a lot of people don't necessarily know that there's this big division between qualified and what's non-qualified. So non-qualified is just like everything in your pocket, cash in your pocket, just basic stocks and bonds, pretty much anything that's not qualified, right? So qualified are those things like 401k plans, 403b plans, the teachers' retirement annuities, the thrift savings plans, and of course IRAs. So most of these things here, because they're qualified, can be rolled over into an IRA, and then you can decide, what do I want to do with it next? And so a lot of you have decided to do a self-directed IRA, which is a great idea. But sooner or later, we have to pay those taxes, okay? And so for a lot of people who had a large IRA, they were expecting to use the stretch IRA. Well, it's like Ted said, I mean, when the Secure Act came out in 2019, it gave us some stuff and it took some stuff away. One of the things it took away was the stretch IRA. So you used to be able to leave an IRA to your children, and then they would be able to stretch it for the rest of their life. Let's just take a look at a quick case study here. Guy that I always like, and we passed on earlier this year. But Donald Sutherland, at 88, he's got $1 million IRA. He wants to leave it to Kiefer. Kiefer's 57. He's at the top of his earning career, and he's at the top of his tax bracket. So when Don passes along and leaves his $1 million IRA down to Kiefer, there's an important stop, and that stop is the IRS, where they're going to get roughly about 30 to 40, maybe even 50% of that, because Kiefer's working and he's in probably the highest tax bracket. Some of you may be able to identify with that. So that was what the stretch IRA did, and then the secure IRA got rid of that, and now it says that, well, hey, we're going to have to get those taxes out of you. You only have 10 years to do it. So Donald passes away, leaves it to Kiefer. Kiefer has 10 years to make those distributions, and he's not retired, he's working, and so they go right on top of his ordinary income. So imagine your top marginal income tax rate, that's what you're going to be paying on that Secure Act IRA distribution. So if we compare the Secure Act to the Stretch IRA, we can see that at age 85, Kiefer's not even dead yet, but at age 85, he has $288,000 left in the Stretch, and he has nothing left in the Secure because he's had to take all the money out. And the value for Kiefer at age 85 was $1 million plus the money that he still has versus $600,036, which is what he would have had at the end of the day with the Secure Act. So you can see that with the Stretch, he would have basically had more than double what the Secure Act is leaving him. So that's the problem, okay? But there is a solution. And this solution came into being essentially with the Secure Act in 2019. This is maybe why you haven't heard of it before, but it's a CRUT, and the CRUT is a charitable remainder unit trust. But the T portion is what's important here. And the T portion means testamentary. So if we have a testamentary CRUT, that's designed essentially to receive the IRA that, remember, is all taxable. So what do we want to do? Well, again, we create a tax-exempt trust. Tax-exempt trust doesn't pay taxes. So what we want to do is we want to make the trust the beneficiary of the IRA, and then we make the heirs the beneficiary of the trust. So it's just a stopover, really. Remember how the IRS was a stopover for the Secure Act? Well, the tax-exempt trust is going to be a stopover for your T-CRUT and your IRA, because we're not going to have to pay those taxes. All the money that would have gone to pay taxes, stays in the trust to be reinvested and to pay out to your heirs. So again, here's Donald, here's Kiefer. Don dies. Instead of leaving it to Kiefer, he leaves it to a tax-exempt trust. But guess what? Kiefer is the beneficiary of the trust. Now we've gotten rid of those required minimum distributions. We've gotten rid of all of those things that we have to deal with. So now the money is coming out of the trust. And in Kiefer's example, it's going to pay 6% to him for the rest of his life. And that starts right the quarter right after the money is funded. So right after Don dies, goes into the trust. The trust starts paying out income to Kiefer right away. It's 6% annually, and that is taxable. It is taxable as ordinary income. We couldn't get rid of that, but we are stretching it. We're stretching it not just for Kiefer's lifetime, but we can go another 20 years past his lifetime to his daughter Sarah. So that, using Kiefer's life expectancy and the additional 20 years, we're really looking at over 52 years of stretching this money, okay? After that, after the 52 years is over, then whatever's left, the remainder, that would go to a charity or multiple charities, or it could just go to his donor advice fund, and then Sarah could continue to dole that money out to charities that she believes in, you know, keeping that in the family. So we just stretched this thing not just for Kiefer's life, which was the stretch, and not just for the 10 years, which is the Secure Act. We stretched it for over 50 years, which is even better than the stretch. So people ask me, well, what's the catch there? Well, here's the catch. The catch is that at the end of the day, at the end of these 52 years, whatever's left in there would go to charity. But initially, when we set these things up, there has to be a 10% remainder interest. So that doesn't mean that 10% has to go to charity. It just means that when we initially set it up with the amount of money that we're going to take out, with the date of birth that we have and the ages that we are, and the amount of time that we want to send it on to the next generation or someone else, that calculation has to equate to at least a 10% remainder interest. And that's it. That's the basic rule. So you can see that with the Secure Act, he got less than $1 million after all the taxes were paid. With the TCRUT, Kiefer and Sarah together were able to get over 2.2. And Sarah's taxes may have been even lower. Maybe she didn't have a job. Maybe she was just a trust kid, so you don't know. So we can see that there's a major, major advantage to using the TCRUT over where we are today is with the Secure Act. I wish we had the stretch IRA again. We don't have it, but we have the TCRUT. And in some cases, in many cases, it's even better. So how do we set up a TCRUT? Well, you have to sign some documents, and that means you have to determine who your beneficiaries are. Well, for me, that's easy. I have my wife and I have my son. You probably have the same situation. We also want to determine who the trustees are. Well, I'm going to be the trustee as long as I'm alive, but after I die, I've got to pick somebody else. That's usually your executor or executrix. We want to determine which IRAs to designate. It's not all or nothing. You can have several IRAs. Some you put in the TCRUT, some you don't. Then you want to sign the trust documents. You got to sign those before you die, so that's important. We go ahead and then change the beneficiary designation on their IRAs to the TCRUT. So we set up the TCRUT. The TCRUT already has beneficiaries designated. Well, now we want to change the designation of your current IRAs so that the beneficiary is going to be the TCRUT. That's important because remember the TCRUT is tax exempt. The TCRUT's funded, no taxes are due, and the payout begins roughly the same year. If you died in December, the end of December, it would be obviously in January. So the only thing that the trustee really needs to do is once a year come in and just sign the IRS reporting documents. We're not paying taxes. We just need to let the IRA, like the IRS, know that, hey, we have a TCRUT, we have a trust, we have money. We're not paying taxes, but we're paying some money out to these people, and they're going to get a K-1 from us. And it's just as easy as that. I know that sounds complicated because you may have never heard it before, but it really works. We've had clients die with it, and we've had currently clients getting paid out with it. So I'm just going to open it up now for any questions. If there are any questions, I'll bring Dave back in. And so Dave can, if you have any questions for me or you have any questions for Dave, and I guess Ted's there, he can answer some questions there too.
Absolutely. Okay, nothing up on questions yet from our attendees, but I do have a question for David.
Yes, sir.
You mentioned in one of the slides, if you die intestate, the state has a plan for you. Can you kind of outline just in broad terms what would happen if you don't have a will, things are not designated where they are to go? What might a state do to the deceased estate?
It's a great question. So if you die intestate, meaning you don't have a will, then your family's going to have to go to the probate court to get permission to administer the estate. Filing a probate petition is essentially filing a lawsuit against yourself for the benefit of your creditors that your family has to defend before they can receive any benefits whatsoever. So they would go to probate court, they would talk to a judge, again, who they've never met, and that judge would decide who was going to administer the estate, and then the judge would determine who your heirs are. Your heirs are defined by state statute. It includes your kids, includes your spouse, if your spouse is still alive, and then it goes out to brothers and sisters and on around the family tree. At the end of the day, if the probate court can't find heirs, then that money ultimately ends up in the possession of the state. So in Georgia, for example, where I am, there's $3 billion of assets being held by the state of Georgia as unclaimed property. That's property that came from probating estates where the beneficiaries could not be found, or there simply were no beneficiaries and the money had to go somewhere. So why give more money to the state than you have to? And why let the state decide who is going to receive your benefit, your assets, and how they're going to receive them? You can avoid all that just by taking a few simple steps now while you're still alive and able to make those decisions.
Okay, great. And got a couple of questions coming on in here. Kevin, this one is for you. One gentleman had asked, can you elaborate on the 6% payout, please?
Yeah, the rules of the CRT of the trust, it comes right out of the tax code, section 664. And one of the rules is the minimum payout must be at least 5%. Okay, so there's maximums too, but you have the minimum payout of 5%, and then you have a calculation of, well, how long do we want to pay it out? So I have one client, for instance, he's 90, and he's taking out 15% because he wants to get his money back quicker, right? Well, again, the minimum is 5, so that's fine. The 6% and 7% is what we use just in general. It's not, the 6% is not written in stone. That's a number that we pick. Generally, what I try to do is I try to figure out how much can we take out and still follow the rules. And then, usually that's in the 6 to 7% range. But if you say, for instance, you had your beneficiary say was 40 years old, okay, or maybe even 38, we could stretch it for the rest of their lifetime if they're 38, but the payout's going to be 5%. Okay, so for someone that's like 25, we wouldn't be able to stretch it for their lifetime because the payout rate would be lower than 5%, and that would violate the rules. So that's where the 6% comes from. I just picked that out of the air because it was the maximum payout rate that we were able to get for Kiefer, plus the 20 years for his daughter. If we were just going to do it for Kiefer's life and he didn't have his daughter, or he didn't, or Don didn't want to have the granddaughter, we could have just done it for Kiefer's life, and the payout rate would have been higher. It could have been 7 or maybe 7.5.
Okay, and can you change the percentage at any time?
No, you can't. One thing about the charitable trusts is they are irrevocable trusts. Okay, so a revocable trust will use your own tax ID number. It will use your social security number. You don't have to get a new tax ID number. But when a trust becomes irrevocable, it's its own entity, like a corporation. Okay, it has its own tax ID number. So these charitable trusts have their own tax ID number, and they are irrevocable. So the trustees, the beneficiaries, the payout rate, all of those things are set in stone when we initially fund the trust. The one thing that you can change are the charities. So your remainder persons, which are the charities, or your donor advised fund, those things can be changed all day long. Now, sometimes I'll have a client, like for instance, I had a client that went to the University of North Carolina at Chapel Hill, and he wanted to have courtside seats for the basketball games for the rest of his life. So we contacted the university and they said, hey, if you will make the university the beneficiary and then also make it irrevocable so that you can't change the university and we will be guaranteed to get that money in the trust, we will give you ringside seats. So you watch a UNC Chapel Hill game today, there he is right there next to the coach, right on the side of the, but that was a case where he had the decision. He said, I have the decision, I can change the charities anytime I want to, but I also have the ability to make it irrevocable so that, you know, UNC Chapel Hill will give me these tickets. We did that with FSU as well, and we did that with the University of Boston University as well. So it's actually pretty common.
Okay. And I have another question that's come on in, and this will be for you, Kevin. Can you talk a little bit more about how the 10% remainder balance in a T-CRUT is calculated? And if the initial value of the asset grows, does that also affect the remainder value?
No, the 10% remainder interest is something that we calculate at the inception. And then it's only necessary right when we set it up. Okay, so it's a present value of a 10% remainder interest. So yes, as we invest that money, it'll go up, it'll go down, it'll go up, it'll go down. And the U in the CRUT is called unit trust. So it's a charitable remainder unit trust. And what that means is it recalculates every year. So kind of like your RMDs on your IRAs, they calculate every year based on the balance, right? So at the end of the year, we say, okay, has the balance of the CRT gone up or has it gone down? Whatever it is, we're going to take out 6% of that number the following year. And then we're going to recalculate it again at the end of the year. Now, there is an alternative called the CRAT, which is a charitable remainder annuity trust, which is to say, okay, we're not going to recalculate it at the end of every year. We're just going to pay out the same amount every single year, no matter what. Okay, but if we're running these things for 50 years, it makes more sense to do the unit trust because, you know, unless you're taking out, like my one client who's taking out 15%, if you're taking out 5, 6, 7%, you know, we're investing half of the money in stocks and half of the money in bonds. So, you know, sometimes over time, these things have a tendency to grow quite a bit.
Okay. And question for both Kevin and David. Are you able to work with clients in all states?
From the CRT perspective, yes, because it's a federal, it's a trust based on federal law, and it has nothing to do with state law. So
Any tax planning really we can do.
yeah, because it's all federal tax planning. Yes, so from the CRT perspective, yes. From the will perspective, no, because wills are state law, and every state has different nuances in terms of their wills. But trusts are good in any state. Irrevocable trusts, charitable trusts, those are good in any state. The only time when we would really need an in-state attorney is if we're doing a will for you there, and maybe we were doing some deeds. I prefer to have an in-state attorney, but I have relationships through my relationship through freewill.org. I have relationships with attorneys in every single state. Sometimes California, New York, I have several.
We're actually a member of several groups that have a nationwide network. So
that's right.
When we have to bring in attorneys from other states, or for that matter, from other countries, we've had to bring them in before. We're able to do that and work with clients nationwide.
I mean, right now we're working with I just finished working with a client in Boston. We sold a property to the Boston University or Boston College. I get those confused. And then we're working with somebody in Virginia. And then right now we're getting ready to do one with somebody in Colorado. And then I have 2 working in California. So, and then on Thursday, we're going down to Orlando to the Money Show to talk to everybody who shows up to the Money Show about CRTs. And those people come from all over the country. So yeah, it's nationwide.
Interesting. And then I have a question for you, Kevin. You know, what about tax law changes? You know, we had a big tax law change in 2017. I guess the one before that was 1986. if there's any sort of a tax law change while you have a TCRUT in place, what may need to be changed, if anything?
Well, the charitable trust has been around since 1971. I mean, the Waltons, used them. A lot of people have used them. There's billions and billions of dollars currently in charitable remainder trusts. So external tax laws like capital gains rate goes up or down, or any of those things happen, or they increase the age on the required minimum distributions, none of that is really going to matter for what we're doing with the CRT. If, let's just say that the tax rate went up on ordinary income and you have a CRT and it's paying out and you're getting some ordinary income, well, it just goes on your tax return like everything else. So there's really no external tax changes that would affect, the TCRUTs in any negative way. I can't.
And we're not aware of any discussion, in forums or anywhere else about changing these rules anytime soon anyway. So,
yeah, the CRT rules are pretty set in stone.
Right.
No one's, there's billions of dollars there. There's tons of people that have those in plan. And let's just say, for instance, that they brought the stretch IRA back, for instance, or they, just said, got rid of all the rules, which would be great. Or you're able to give your IRAs to a CRT when you're alive. You don't have to die. If you haven't died and you have that CRT in place, it hasn't been funded because you haven't died, you can just change the beneficiary designation on your IRA to something else. So you're never locked in until and if you die, right?
Right.
And then at that point, well, you're locked into pretty much everything. What do you say?
Great. And looks like one final question just slid in. If someone is in the 10-year drawdown on an inheritance from a parent, is there anything they can do at this point to reduce the impact of taxes with that added income?
No, I mean, it's ordinary income. You can give it away, but it's IRA money. It's never been taxed, and the whole point of the Secure Act was to accelerate those distributions, so the IRS would get their money, and there's just no other way around it, unfortunately.
Okay. Any other questions from any of our attendees? Okay, that looks like that's it for questions, and ironically, we're right up on time. Yeah,
Well,
absolutely.
Appreciate it, Ted.
With that said, my thanks to both of you, Kevin and David. Great presentation to our attendees. Great questions. We always like to see robust questions come out of these. And with that being said, feel free to reach out to myself if you have any further questions, or perhaps if you would like to get in contact with Kevin and David. I have their contact info. I know they've made their info available, and we're also going to be posting a copy of this presentation on our website at advantaira.com, and it will also be on our YouTube channel. Just go into YouTube, type in Advanta IRA, and you'll see the entire library, including this presentation. It'll be available in approximately 1 day.
Thanks, everybody.
Thank you very much.
Okay. Hey, thank you, everybody.